Welcome everyone who's joining us. We're excited to be here, and we have Jeff Biller, of course, who recently published a paper, The Strategic Use of Ransomware Operations as a Method of Warfare. I have the distinct pleasure of working with Mr. Biller, and it's an absolute pleasure and a great amount of knowledge on this subject. So thank you so much for joining us, Jeff. And
happy to be here.
I'll let you take it away from here.
All right, I'll go ahead and share my slides real quick. Get those going. All right, can you see the slides okay?
I can see them, yes.
Okay, great. All right, so as mentioned, I'll just give a quick background of who I am. So as you mentioned, currently teaching at the Air Force Academy. I'm actually on faculty with the Department of Law, and I also work with CyberWorks, which is an innovation organization that operates out of the Air Force Academy, solving problems for the DoD. I act as their law and policy advisor and participate in a number of projects that they have ongoing. As far as the courses that I teach at the Academy, I have taught the cyber law course in the past, which Major Bradford's currently teaching. I teach cybersecurity policy and politics, international law, as well as our core legal class. A little bit of my background: I'm a retired Air Force JAG. Spent 20 years on active duty in various roles: SEER instructor, intelligence officer, finally as a JAG, where I worked in the latter part of my career with our cyber units as well as our intelligence units on advising signals intelligence, cyber operations, etc. I finished my active duty time out at the Naval War College. I think I saw Professor Schmidt online there, working under his mentorship. And finished my career out there, really fell in love with teaching in the academic enterprise, and was fortunate enough to find a position at the Air Force Academy. Most of my research has involved cyber operations and law of armed conflict or international law issues, which kind of brings me to this paper and why I decided to write on this subject. And I think there's a number of reasons why I found this kind of an interesting topic that I wanted to research and write on at the time. One of those was I was thinking a lot about the kind of the nature of cyber operations and how the nature of those operations affects our understanding of the law as related to them. Cyber operations are very exploitive in nature as a general rule, right? As opposed to being coercive. So most of the time, I would say 99.99% of cyber operations are simply seeking to find an exploit and then take advantage or find a vulnerability and take advantage of that vulnerability to exploit information or to garner some other kind of advantage through the exploitation of adversary enemy networks, or just enemy networks in general, if they're not, even if not adversary. And this is true, I think, both kind of in the criminal realm and in the state realm, right? And so I guess maybe that might require a little bit more explanation, and that most military or state operations, even if they're not military, seeks to be coercive. They're trying to get another state to do something that they want them to do, right? Which is why most of our law is built around deterrence and deterring those states from that coercive behavior, right? So the Russia-Ukraine example is kind of perfect here. For a long time, Russia was seeking to coerce Ukraine into more strategic alignment with them as opposed to the West, to prevent them from joining NATO. Ukraine was seeking to deter the Russians from taking Ukrainian territory. And so it existed in a very coercive behavior. And if you look at the law that largely governs that interaction, it's built around the deterrence of coercive behavior. But most cyber operations don't work that way. Generally, right, an operator is looking to find a vulnerability that they can exploit And then they exploit that vulnerability for as long as they can until the adversary or the owner of the exploited network discovers the exploit, patches it, and stops the ability of them to do so. But there's very little conflict in that space, right? At least by conflict, I mean simultaneous, right? It's not like maybe you might see in the movies where you have hackers on each side going after each other. That's not generally how it works. And so deterrence models don't generally work all that well. And so I think that's where a lot of our law falls short, is it falls short in that it is seeking to deter something which isn't coercive in nature. Hopefully that made a little bit of sense. I also started thinking a lot about the Russia-Ukraine conflict and how we saw a lack of significant cyber operations as part of the conflict. And there's numerous reasons for that that have been covered in other forums. But I think it gets back to the question I just raised, is if cyber operations are exploitive in nature, then how are they going to be used in a conflict, particularly one that's become as brutal as that conflict has, right? And so why utilize cyber operations to achieve an effect when you can just drop a bomb to do so? But anyway, those are kind of the impetus for why I started researching it and looking at this project. And I think looking at it through the lens, the method of warfare lens through ransomware operations forces you to ask some questions as to the general nature and understanding of international applied to cyber operations in a new way that maybe cuts a little deeper at some of the questions that have been traditionally asked. So it really challenges the application of international law to the cyber domain in kind of a new way. And it highlights the issue of protecting civilian data in a way that could be used strategically, and that is to sway public opinion. So that was the reason behind looking at the paper, because ransomware operations are, in my opinion, one of the few ways to use cyber in a coercive manner, right? Its very nature is designed to force the other side, the exploited network, the adversary, or whatever, to take a certain action that they would not have otherwise have taken. Typically in the criminal realm, right, that's through the form of payment, which is basically what ransomware operations are. I find an exploit in your network, I encrypt your data such that you can't access it, and then I demand some sort of condition to be met in order to release the encryption so that you can utilize that data again, typically in the form these days of cryptocurrency. And so in that way, it is very coercive, right? But it's one of the few ways to use cyber in a coercive as opposed to exploitive manner. Okay, so what's in the paper? So here's the table of contents from the article. No better way to explain what's in the paper than the table of contents. So I go through kind of a general introduction of ransomware and talk about a little bit of the history of ransomware and how it's been used, particularly about how it's been used against states or governments, because I think that would be particularly relevant to this particular conversation.
And Professor Biller, as we get into the substance, if you don't mind, we discussed previously that you'd be happy to take questions throughout, waiting to the end. So I'd invite anyone who's listening to go ahead and type in your questions, or I think we even may have a way to give you audio. We'll figure that out when it comes, but there is a question and answer portion down there. So questions are welcome all along the way.
Yeah, I'd love to make this a little more conversational than just talking. So I'm more than happy to stop at any point and address any questions. So, for example, we seen recently a lot of ransomware operations against city and local governments in the United States. I think there's a couple reasons for that. One of those is that those city and local governments are often under-resourced, particularly in terms of information technology, and so they possess a lot of vulnerabilities that can be exploited. But also, and this is where I think is particularly important to this topic, is that so much of what state and local governments do are dependent upon by the civilian populace on a day-to-day basis, right? So for example, the ransomware operation against the city of Baltimore resulted in a large swath of government services being shut down for an extended period of time. Nobody could conduct a real estate transaction in the entire city until they resolved that situation. And as a result, there was an intense amount of public pressure to have the ransom be paid, right? Because they wanted a restoration of those services. So anytime you can get public opinion on your side to try and meet the condition that you're coercing your adversary into, that has potential strategic effect. And so I think it's really interesting to look at those ransomware operations, particularly against state and local governments, to see how they have worked and how successful they have been, and what kind of coercive pressure can be put upon governments when it comes to basic services for the populace. All right, so again, some background on ransomware. And then specifically, I start looking at its application to international law, particularly against civilian data, right? So could ransomware operations be used against military targets or targets that we would generally consider to be valid in the IHL context? Absolutely, right? But I don't think the legal issue there is tremendously interesting. The legal issue is much more interesting when you apply it to civilian targets, right? Yeah. And I'm by no means the first person to address that. There have been many excellent papers, but again, I think when you start to look at some of the specifics of ransomware and how it works, I think it raises new questions that needed to be addressed. Okay, so particularly there, right, if we're going to look at civilian data, then we have to talk about the rule of distinction and how we've looked at distinction in the context of cyber operations. And the two primary questions that always come up are whether or not data qualifies as an object and what constitutes an attack under IHL such that the targeting rules apply. Again, these have been raised by many people more intelligent than I and have explored in depth. But I do think that, again, ransomware raises different questions that need to be asked. And so it's worthy of readdressing those subjects in the context of ransomware. And then we move on to special protection. So there are a number of categories in IHL of objects that are protected in a way that's different than the traditional targeting rules, right? We call those special protections because those protections are above and beyond what you might see in other categories, or they exist in a different sort of way than traditional distinction, proportionality, and other targeting rules for most objects in the IHL context. So we look at a number of, certainly it's not, the list isn't exhaustive, but I picked out some that I thought were particularly interesting: digital cultural property, medical and religious data, journalist installation containing dangerous forces, civil defense, objects indispensable to the civilian populace, and the question of collective punishment. So I kind of address each of those in turn because the protections that exist for all of them are unique to each one of those categories. And so thinking about how strategic ransomware operations might exist there is individual to each one of those categories. Then we look at the question of targeting war-sustaining objects, right? Another topic that's been covered in depth, but one that I think has to be addressed here because of how I imagine that these ransomware operations might be used strategically. I think the best effect would be to go after targets that have high economic significance for the populace. And so therefore, the question of war-sustaining objects comes up. And then finally, because my ultimate conclusion is that by and large, the law as a general matter does not prohibit the use of these types of operations, we have to look at potential normative limitations on the use of ransomware if we want to prevent states from targeting civilian data with ransomware operations. So that's the general outline of the paper, and I'll go through that general outline in kind of a similar fashion in this webinar. And I realized in my introduction here, I might not have given a full explanation of why states would want to utilize ransomware. And is that in my Yeah, I should have been flipping my slides a little bit more here. So we talked a little bit about this offer already. So why ransomware? Okay. Again, ransomware is a inherently coercive tool. I am trying to get somebody to do something they would not have otherwise done, right? And warfare is very much a coercive tool. Again, if we go back to the Russia-Ukraine conflict, Russia is trying to get Ukraine to cede territory to them, and perhaps install a pro-Russian government. Ukraine, and I'm breaking this down obviously very simply, I know it's much more complicated, but for our purposes, and Ukraine is trying to get Russia out of their territory and cease military operations against them, right? So they're both trying to get the other side to do something. And from a strategic standpoint, if they could find a means to pressure them into doing that, then that would be something that they would potentially want to utilize. So why ransomware? Well, ransomware could be likened in a strategic way to some of the strategic bombing campaigns that we saw in the 20th century. While they weren't always the stated goal, there was clearly an intent to try and pressure the civilian populace, or to influence the civilian populace to pressure their government to cease the military campaign, right? If we can make it painful enough for the civilians, then they will want to end the conflict and they will pressure their government into ending the conflict. These were not very successful because, as it turns out, bombing the civilian populace only angers them, right? And in a way reinforces their desire to continue with the conflict. They haven't been very successful. And I think from a human nature standpoint, there's a certain amount of sense that makes. You know, it turns out watching your neighbors be bombed, watching your village or your city be destroyed, tends to anger individuals, right? And then if your city has already been bombed, if everything is already destroyed, then why cease the conflict at that point, right?
Yeah, what do you have to lose?
Yeah, what do you have to lose, right? However, if I could achieve that same thing without any permanent damage or even visible damage, then that might affect the calculus of the pressure, right? And then that goes back to what we see with ransomware campaigns against city governments, where once you start affecting critical functions that are performed for the civilian populace, but yet you can't really see, it's not like things have been visibly or overtly damaged, then that might change the calculus. And I don't know, this is speculation, right, at this point, but I could see states wanting to try to do something like this. And it goes back to what is really the theme of this whole research exercise here, is the temporary and reversible nature of ransomware. In a way that's different from other types of temporary and reversible cyber operations that are out there, such as denial of service operations, and that it is entirely at the will of the operator as to when the coercive behavior starts and when it ends. And they can do that at any time. And theoretically, at least, particularly if you have an advanced state actor doing this, the ransomware can be targeted and efficient enough to be able to do that, right?
So really there's no kinetic equivalent to that, would you say? I mean, you bomb out a city, right? You can't give the city back, but with ransomware, instead of the civilian populace having nothing to lose, if they concede, then they can get back everything they've lost.
Right. Yeah, I think there might be some, and we're going to explore those a little bit, analogies, such as the seizure of property, right? So sometimes in warfare, militaries will seize property for military purposes. Maybe I don't want the civilian populace to be able to drive for a particular reason, right? While I'm invading that city or something like that. So I seize the property as opposed to destroying the property. And so that is a question that I look at here, as opposed to, going in and damaging the car or destroying the car. What if I just seize the car or lock a person out of the car so they can't use it temporarily, and then give them the key back to the car when I'm okay with them using it again? And so I do think there are some analogies there to the seizure of property, but we'll look at those in a minute. Okay. Do we have any questions yet? No. Okay.
We actually just got one from John Bergstresser, which
Oh, great.
is, how are we defining temporary effects though? Is a week considered temporary, or are we looking at a shorter term?
Yeah, and that's a great question, and I'll get into it a little bit more, but for now, that's kind of the point of ransomware, right? Is you don't know how long it's going to last. Theoretically, right, your adversary could give in to your demands immediately, and the effects could be quite temporary. Theoretically, they could choose never to give in to the demands, and the effects could drag on for weeks, months, years, right? Obviously, they will attempt to break the encryption, and depending upon the sophistication of the actor, right, it depends on that timeline, particularly if we start to develop things such as quantum computing and the ability to break encryption faster. But, right, theoretically, at least, it can be as brief or as long as the situation plays out, in terms of both, you know, the party that's exploiting the vulnerability, that's utilizing the ransomware, and then also the victim, if you want to call it, in this case, in an armed conflict context, the victim. But that's a good question, right? And I think it gets to the heart of why this is a little bit different than other types of cyber operations.
So I have kind of a general ransomware question. I'm not sure if you're going to talk about this later, so I'm happy to wait. But you talked about in your paper a few of the a few cyber operations that kind of came out into the world, some starting with Russia, targeting Ukraine, but then some of that code kind of got out and affected the whole world. And I don't know how to pronounce it. Petya, not Petya, want to cry.
Okay, yeah, so yeah, right, there's debate. So the original Petya was certainly ransomware, right? Not Petya, which is, I think, in part why it's called not Petya, looked a lot like the original ransomware, but it really wasn't utilized as ransomware. It was more just utilized to disrupt or altogether destroy data for certain targets, originally utilized by Russia against Ukraine, but then it like you just said, spread out all over the world. And affected a lot of targets that had nothing to do with the Russia-Ukraine conflict. And so there, you know, and a lot of people have written on NotPetya in the past and analyzed its use as part of that armed conflict. There are some very good posts on that I recommend to people, but it wasn't really utilized in the conflict as ransomware. Right? It wasn't like they encrypted Ukrainian data and then demanded Ukrainians do things, and then once they did them, then they could release the encryption.
And you pointed out that countries haven't really been using ransomware in warfare directly yet.
No.
I guess my question is, you at least predict or foresee the possibility that will be on the rise. So if larger, more sophisticated countries like Russia, United States, China, whatever, does warfare involving a more sophisticated country increase the likelihood of malicious code kind of spreading out to various nefarious users? I mean, if these countries are developing it, do you have any thoughts on that?
I mean, yeah, I mean, certainly there is no cornering of the market on ransomware, right? Obviously, there are actors all over the world who are utilizing different ransomware capabilities. I think if you were to see it used in warfare, it would depend upon the sophistication of the state that was using it, right? Perhaps they contract out to a criminal ransomware gang to conduct these operations, right? A more advanced nation state would probably seek to do it themselves and use more targeted capabilities to better achieve the effects that they want to achieve. But yeah, I think it would attend entirely upon the level of sophistication of the actor doing it. Right. Certainly Russia and the Russia-Ukraine conflict, when they were using NotPetya, didn't seem to care at all if this this malicious code, this malware, this capability went out beyond the conflict. But I think a more sophisticated actor could certainly do it in a more narrowly targeted way.
Thank you.
Okay. So let's get on to the actual application of the law to this potential method of warfare. So there's no doubt that international law, including the law of war, I think applies to military cyber operations. I think this is a question that's been asked and answered, right? So you can point back to the UNGG on cyber from 2015, affirming the application of legal principles to cyber operations. And if you're going to discuss the intentional targeting of civilian data with any kind of cyber operation, the first question that would need to be asked is, doesn't this violate the rule of distinction that says civilian objects shall not be the object of attacks or reprisals, right? And there are two questions that primarily come up. I apologize if you're familiar with this topic, you've probably heard these discussions to death, but in case you haven't, let me introduce kind of where the debate is on these two particular aspects of distinction, right? So if our rule of distinction under international humanitarian law says that objects shall not be the object of attack, then it becomes necessary to define what an object is, right? When this rule was written, I would say what an object is fairly obvious, right? But the digital age raises new questions as to what counts as an object. And so if you're the proposed target is data, then you have to ask, okay, is data an object? So by the way, the two things that get protection under IHL are individuals, people, right, and objects. If we're talking about cyber, obviously the best answer would be that it constitutes an object. But we traditionally understand objects to be things that are visible and tangible. If you go back and look at the commentaries to the additional protocols, they talk about objects being something that's visible and tangible. And data, unless you have it's manifested through a graphical user interface, is not something that's visible and tangible. You can't see it, you can't hold it, right? You can see the effects of some sort of tampering with the data, right? If you can't access it, right? Anytime you try and open up a Word file and it says it's corrupted or some other reason, you see the effect of something happening to the data, but you can't see it, right? Unlike dropping a bomb on a house where you can see the damage to that object. The same is not true with data. And so a number of solutions have been proposed to try and understand this issue better, right? One is to just say that, well, look at the object and purpose of international humanitarian law. That's to protect civilians, and in this day and age, civilians are dependent upon digital data, and so therefore the object and purpose would seem to suggest that data should be something that counts as an object that's protected. However, right, our interpretation of treaties also says you have to give, read words in their plain understood language. And most of the time, data is not viewed as an object, particularly under the law, right? We protect data often as intellectual property, but not something as personal property or as something, right? We protect it in a different sort of way. If you look at domestic US law, right, we have anti-hacking statutes, such as the Computer Fraud and Abuse Act. We have intellectual property and copyright protections. But we don't view it as the same way as a book, right? In terms of its protection as personal property. So for example, right, Trent, I could go in and I could take a book from you and steal it, and now you no longer have it and I do. But if I hack into your computer and make a copy of the book and bring it back, you still have the book, but I have the book now as well. And so because of that, we have to think about it differently, and that's why it receives usually protections as intellectual property and not some other sort of property. So this question of whether or not data constitutes an object is one stumbling block. Let me forward in my notes that I have here just to make sure that I'm covering everything I want to. And then we have the issue of definitions of an attack, right? So if we look again, civilian objects shall not be the object of attack or reprisals. So what is an attack? Well, the treaty tells us that an attack is an act of violence. And again, is tampering with data, right? Degrading it, denying its access, even destroying or deleting it. Does that count as violence such that it would constitute an attack? Because if we don't have an attack, then Article 52.1 or the other provisions of the law that relate to protection of civilian objects don't come into play. And so this has been another area that's been subject to a lot of debate because of the sticky issue if you have that word violence. Right? If I drop a bomb on a server, right, that's certainly a violent act. And you can even argue, right, if I insert malicious code that causes the cooling fan of a server to turn off and actually physically melts the server, right? That's visible. That's something that I could say that's violence that's being done to that particular server. But if I just go on and delete the data, is that really a violent activity, right? Not according to our traditional understanding of what violence would look like. It may be that our traditional understanding of violence needs to change. However, it really is up to states to make that change, right? And so in the paper, I go back and look at a number of different state positions on these questions and try and determine what states have to say about this. And I ultimately come to the answer, and this is certainly debatable, I have no doubt about that, but that states come to different answers on this question. Therefore, you can't really say that the fundamental definition has changed, I don't think, right? A good example, if we look at the definitions related to data and attacks, we have 3 different states that we could look at, New Zealand, France, and Israel, just as an example of the different opinions of states. France, for example, takes a line that would, I think, certainly include operations that affect data as attacks. So here they say, when the targeted equipment or systems can no longer provide the service for which they were implemented, including temporarily or reversibly, where action by the adversary is required to restore the infrastructure or the system, that would constitute an attack, right? So I think if you look in the ransomware context and you say, okay, it says even temporarily or reversibly, if it affects the functionality of the system, then that's an attack. So I think under the French definition, you would certainly say that it counts, right? On the other hand, you have the Israeli definition that says that it requires physical damage to qualify as an attack and excludes the mere loss or impairment of functionality to infrastructure. So here, right, under the Israeli definition, I would think you would say it would be very hard to argue that ransomware operations qualify as an attack.
Now,
And
France,
then you have, what's that?
France and Israel also disagreed kind of on the definition of data as an object.
Yeah, there's a number of areas. Yeah, and I think they kind of track with France in general and some other states taking a much more forward line and seeing any sort of affecting of data or information systems as an attack. And then on these similar questions, Israel may be taking a different line.
And Jeff, we do have a question from Mike Schmidt.
Sure.
You are citing API and the interpretation of rules of interpretation in the Vienna Convention, but some states, like the United States, are not party to the instrument, but instead bound only by customary international IHL rules. Might that fact give non-party states more or less leeway? Consider France an API state compared to Israel, a non-API state.
Yes, absolutely right. I think it might give them more leeway. Although I think, even when we go to customary international law and we look at the customary international law studies, they generally track pretty closely with what we see in Additional Protocol 1. And the US accepts most of what's in Additional Protocol 1 as customary international law. So I think if I'm responding to the question that's being asked. I think yes, there's possibilities there, but I think if you ask as a general rule for states out there, if you look at the specific question of going after civilian data as part of military operations, I think these questions, whether or not you're relying on customary international law or the additional protocols if you're a state's party, I think they're going to track very closely. And I do look in the paper, I get a little bit more into some of the customary versus AP1 discussions. But for the purpose of the webinar here, I was just looking at the additional protocols. I apologize if I didn't fully answer the question, and feel free to press me further if I did not. I think most states are moving maybe towards a little bit something like New Zealand, which I would call the position that's a little bit in the middle, where they define it as attack as a loss of functionality equivalent to that caused by a kinetic attack, right? So they recognize, I think, that it needs to look something more like what would happen with a kinetic attack in order for it to qualify under the law. But they do recognize that loss of functionality could rise to that level, even if it's not loss of functionality caused by an explosion or something physically happening, right? And so even if you take that middle position there, I'm not sure that ransomware would qualify as an attack here, because when they say equivalent to that caused by a kinetic attack, I think that suggests more long-term damage, right? Or damage of a different nature than you see with ransomware, which is theoretically instantaneously reversible. Whereas something equivalent to that being caused by a kinetic attack is not instantaneously reversible. And that's where I think the ransomware question becomes really interesting, because it's not just that it might cause loss of functionality. Although with ransomware, it doesn't necessarily cause loss of functionality, right? It just might cause loss of access to a certain data set. So again, it's simplistic, but think of our Microsoft Word analogy, right? I might be able to go into your system, Trent, and prevent you from accessing all of the documents that you have produced, but that doesn't necessarily mean I've prevented you from using Microsoft Word. It just means I've locked you out of your current research projects or your current syllabi or your current whatever you're working on at the time. Particularly if you're a sophisticated actor, you can be really targeted. So you might not even be affecting the functionality. You might just be affecting the access to certain data sets. Is that total loss of functionality? No. Is it partial loss of functionality? Yes. Is it loss of functionality equivalent to that caused by a kinetic attack? I don't think so. And so, but I wanted to point out that these positions are pretty varied, right? They're pretty all over the place. And so I think to argue that there is a consistent rule here that's developed among states such that you could say it clarifies the additional protocols or constitutes new customary international law related to this particular question, I'm not sure that you can argue at this point that it's happened. It very well may in the future, right? But given the inconsistency interpretation that exists right now, I don't think you can say that we're there as of yet. But again, it gets to this very nature of ransomware being temporary and reversible in a way that's fundamentally different from other types of cyber operations where that temporary and reversible question comes up, right? And we see this in other areas of the law as well, right? So
actually, before you go on, if you don't mind, Mike has another, sorry. Mr.
Yes, please. I know he's going to ask hard questions too, so.
Good.
And as he should.
On data, the French distinguish between content and processed data. It argues that an attack on content data is an attack on an object, but an attack on processed data is not, unless it results in damaging effects. So my guess is that the French would not treat a ransomware attack as an attack on an object. Does that make sense to you?
Yeah, I think so. Yeah. And that gets towards, right? Sometimes right? There's that distinction between operational level data and content data, or you can use different words to describe those, right? So operational
Kind of
data,
like you were mentioning, taking away my Word documents versus ruining my computer system or something.
right? Yeah. Oftentimes ransomware operations aren't that sophisticated, and so therefore they dramatically affect both, right? But they can also affect all sorts of processes. Go back to the Colonial Pipeline ransomware operation here in the United States. So operation against critical infrastructure, not IHL here, but right, all they did was affect the access to customer accounts as part of that ransomware operation, but it had the effect of preventing the flow of gasoline or whatever else was being transported through those pipelines, right? So it very much, even though all it did was restrict access to a certain part of that operation, right? It didn't actually affect the pipeline itself, but overall, it had the effect of cutting off the supply of an important asset, right? And obviously, sophisticated actors can be more targeted in what they do, right? So, for example, right, I might continue to allow you to operate and use your system, your computer, while preventing access to certain data sets that exist on it. Or I could affect that operational data and not allow you to do anything on your computer, right? Those are different types of affecting of functionality. And I certainly see why states might want to parse out a different legal understanding for those different types of data sets. Although again, I don't know that if you look at most states' understandings, they don't get that specific. And they may eventually, and I hope they do eventually, but at this time, I think that's, you're really starting to target and down to individual states and their individual understanding at that point.
So I found the allow to talk button, so I've allowed Mr. Smith. If you have any follow-up and if you have a microphone.
No, I
jump in.
If I'll let Professor Schmidt sign on if he wants to, because I may not be getting at what he's asking. Okay. Well, for now, I'll go ahead and move on. Well, I'll ask you, as the host, do you have any other questions or things that might come up in terms of the application of the rule of distinction to ransomware in particular?
Well, I had one question come to mind, but I think you may be addressing it later on, which is where these rules are so, I guess, not exactly set in stone on an international level, where there's still a lot of debate and question marks. Toward the end of your paper, you talk about norms. And I was wondering what you think about the development of norms in this particular sense that we're talking about here, protecting civilian data. My guess is there's not a lot out there either, but I wondered what your thoughts were on that.
Yeah, no, we can go ahead and jump forward to that now. Because I think I have a slide for it at the end, but we can discuss it now. That's an easy one. Yeah, I think, right. So if we think about the development of law, we have hard law for special protections, which we're going to get to in a minute. But I think most of those developed kind of in a normative sense, right? We started to maybe not feel legally bound to not target these certain objects, but we understood from a normative that maybe there are things that we want to leave alone, right? For moral, ethical, or even practical reasons, that these are things. And then as enough states recognize that normative limitation, then eventually it does ripen and crystallize either into customary international law, or states come to an agreement and a treaty regime to protect those certain objects. And because of how, right, and we're going to look at, I think many of those special protections do apply in the ransomware context, and we'll get to, but there are many things that do not, right? And just in general, when you talk about protection of civilian data, there are many things that do not apply under those special protection regimes. And so I think the first step in that right now, because I don't think states are prepared as of yet to come together and really crystallize that either into customary law or to come together and do a treaty regime, is to start getting as many states on board on a normative limitation, right? And I will again point back to Professor Schmidt, who in his paper Wired Warfare 3.0 went through many of these in a very elegant way that I recommend to everybody, and what types of normative limitations that we might want to enact as it relates to civilian data. Because certainly I think we can all think of certain things like the pensions of the elderly, right? Doesn't really fall into a special protection. However, I think we could probably all agree that that's something from a moral and ethical standpoint that might want to be off the table, right? And there are many, many categories that you could come up with. And so at this point, right, if we are going to say that the normal rules, the normal targeting rules, the rule of distinction does not apply to ransomware operations, or to other types of cyber operations, then I think we might want to start to think about forming those normative limitations as that first step and moving towards that. Okay. That answer your question?
Yes, thank you.
Yeah, good question. Okay. So why are special protections different than our normal targeting rules, right? If we say, well, if that is not an object, then why would they be protected differently as a special protection? And that's because of the language that's used in those special protections. And again, it's individual to each protection, so we have to walk through them. But in general, it uses language like respect and protect. So medical data will be respected and protected. And that has been interpreted broadly as you will not affect the functionality of those systems, right? So you can't do anything. Respecting and protecting means not doing anything to interfere with the functionality of a hospital, right? For obvious reasons. But it goes beyond the limitations of violence or of attacks. Or it's not so concerned as to whether something is treated as an object or not. It's more, are you affecting the functionality of that particular thing that's being protected? And if you're not, then you're not respecting and protecting it, and you're violating the special protection, right?
So this makes it much more easily applied to ransomware.
Yeah, exactly, right? And again, there are some things that I think are different about ransomware than other types of cyber operations, which are generally designed to degrade or destroy data, right? Particularly as you might think about in an armed conflict, whereas that's not the aim of the ransomware. In fact, with ransomware, right, just to hammer the point home again, if you were to corrupt the data or destroy the data, then your ransomware operation isn't going to work anymore, right? Because there's no incentive for the other party to meet with your demand and release the data back to you if you've done something harmful to it, right? You need to preserve the data in as pristine a state as possible in order for you to fully leverage that capability against your adversary and get them to comply with your demand, right? If you run a couple of these and you show that all you end up doing is destroying the data, then the other party is not going to want to comply.
Yeah,
because they have no incentive to do so. Okay. Cultural property. This might seem an odd one to start with, and I start with it because it's something that I've been kind of playing around as a potential interesting research subject as to whether digital things can amount to protected cultural property. And this gets into the interesting question of non-fungible tokens in particular, right? So for those not familiar, right, using kind of blockchain technology, you can essentially identify the originally created digital work of art or news article or whatever the case may be, the original of that. If anything, digitally can really said to be an original. And then essentially you've got the original. Like normally with digital, we would never think about having the original because the copies and the originals, there's no difference, right? If I have an actual work of art, right? There is always the original. You can reproduce, repaint all you want, but you can physically, tangibly identify what the original one was. It's much more difficult digitally, but now with non-fungible tokens, that actually exists as a thing. And if you think it's just a whim or just kind of a neat trick, but not really relevant, right? You can look towards, in the paper I cited, in 2021, a non-fungible token sold for over $69 million at auction, right? Well, if something if you believe that things are worth what people will pay for them, and if something is worth $69 million, I think it's worth asking the question of whether or not that might constitute cultural property. And if so, cultural property receives those protections. There's an obligation to respect such property. And if the ransomware you were to somehow interfere. Now, right, it raises questions. You could almost make an argument that you're trying to actually protect it in warfare by encrypting it so that nobody else could damage that non-fungible token. But anyway, I think it's kind of an interesting question to ask whether or not we've reached the point where digital items can become cultural property, because if so, then they receive special protections, which means you can't interfere and with the ability to, I guess, access that cultural property. I think of a more relevant or important question is the second one of medical data. And this is one where I think you probably have the highest level of protection when it would come to a ransomware operation. So at all times, medical data shall be respected and protected, which means you can't interfere. Because obviously, if I were to conduct a ransomware operation against medical data and interfere with the hospital's ability to access it, I am obviously interfering with the functionality of the hospital and their ability to provide the intended service. Yeah. And so therefore, that would be a clear violation of the obligation to respect and protect medical data and medical units. Well, medical units properly, but the data that they would be relying upon to do their job. And this one's also interesting because as the law has developed as related to medical units, it's not just medical units providing services to the armed forces as a party of as a conflict, it's medical units broadly, right? And we're going to see how this is different, say, to our next category, religious data. But certainly there's that obligation to respect and protect medical data. And so I think a ransomware operation that affected medical data would no doubt violate that special protection, violate international humanitarian law. Again, this is to distinguish it from religious data. And the protections there are related to religious personnel, but they only extend to those providing ministry to the armed forces, medical units, and civil defense or organizations, such organizations. So it would not have broad applicability to religious data. So if you were to, right, particularly if you were dealing with a religious country, right, that placed a high value on the provision of religious services, to interfere with religious data, interfere with the ability of clerics or religious personnel in that country from providing religious services to their individuals, right? Then that could be something that could be a pressure point, a strategic pressure point on a country. But because the protections on religious data in IHL only extend to those protections being provided to the forces, right? Then you're not talking about the civilian populace in general. So a similar type of protection, and that it gets towards the interference with the functionality of religious personnel, but much less broad than medical data.
Is it significant that this rule says respected, but it doesn't include the word protected?
That's a good question. And I'm not exactly sure to the answer to that. I'd have to think about that more. I think I read it as being a similar protection. And when I was writing the paper, I might have dig deeper into that question, but it's not coming to my head right now. That's one I'll have to save for later.
Fair enough.
Okay. Journalists. right? Journalists do receive some protection that's a little bit different from civilians, but it really relates to attacks. So here, when you talk about journalists, right, because, hey, again, a potential pressure point, ransomware operations against journalists and the data of news companies, the ability for them to communicate with the public, that could be a pressure point on a civilian populace. But the respect and protect language does not exist at all as it relates to journalists. It's more of a additional protection from attacks, from violence against journalists who are accompanying the forces, right? Because they wouldn't qualify as combatants. So I think the idea was to give them some protection there if they were accompanying the forces, but they don't have that same aspect of they're being protected from the interference with the performance of their function, providing news services to whether it be the forces or to the civilian populace. Installations containing dangerous forces. Again, you don't have the respect and protect language there, but when you look into that particular protection, it protects against if such an attack against a dangerous force were to cause the release of dangerous forces and consequent severe losses among the civilian populace, that's where the protection exists, right? So it's not a general protection against everything that you might target an installation containing dangerous forces. But if the activity, I think, were to release those dangerous forces with the attendant consequences on the civilian populace, then I do believe that would be something you could argue would be protected from ransomware operations, right? So if my encrypting the data of one of these installations prevented the people functioning that installation from performing their duties with the expected cause of releasing those dangerous forces, then I do think that's something that would receive that special protection. Similarly, with objects indispensable to the civilian populace, we don't get that respect and protect language. But this one was, you have a different phrase than just an attack, right? Here it says it's prohibited to attack, destroy, remove, or render useless objects indispensable to the survival of the civilian populace, right? So, as we go towards a more and more digital age, where more and more things that provide services to the civilians, including things that are indispensable to their survival, right? Think of the provision of water, for example, right? And how we have SCADA systems controlling the provision of water. I think if you were to conduct a ransomware operation that were to render useless a water treatment plant that was indispensable to the civilian populace, right? Then that is something that would certainly receive protection. So it doesn't have to be that respect and protect language. You have to, I think, get into the individual details and think about how a ransomware operation might affect, right? That, and if it were to affect that object in that particular way, then it would be something that would be protected.
And Professor Biller, Professor Schmidt has a question on objects indispensable.
Yes.
Professor Schmidt, if you want to just unmute and go ahead and ask.
Hey, Jeff, a very interesting presentation. Greetings from your old home in Rhode Island.
Yes.
I actually had a question about installations containing dangerous forces. I miswrote the question in the block.
Okay.
So the question is, this is different from all of the other protected categories. And the reason it's different is installations containing dangerous forces are very often military objectives. Certainly, if you have a nuclear electrical generating station providing power to military facilities, a dam across which there is a road, et cetera, et cetera. So they're military objectives in many cases.
Correct.
And so this rule's a little bit different. And I want to get back to the AP1 issue again. If we are applying AP1, I certainly agree with your analysis, but I wonder if you could analyze it from the perspective of an American. So let's assume we have a nuclear electrical generating station that is in fact providing even a small degree of power to the armed forces, and therefore qualifies as a military objective. How would you do the analysis then?
Right. So I think this gets, I would say if it's a pure interference with the functionality of that system, right? Now this brings it into the realm of targeting law. If you're saying if at least in small part it provides power to military forces, then yes, it becomes a military objective. And then you would have to do your proportionality analysis comparing it to, all right, well, but what is the effect on the civilian populace, right? Is it the only power for, northern Alaska in the middle of the winter where people are going to die if they don't have power, and it's only, providing minimal amounts of power to a local military installation, right? Well, then maybe it fails the proportionality test there. But if you were to completely remove the military objective portion of it, right? Then I think that's when it potentially, for something like a dam or now that could also be objects indispensable, I suppose, but it also brings it back to the installation containing dangerous forces, right? If I'm talking about a hydroelectric dam and the ransomware operation has a high likelihood of causing a failure of the dam, right? Then even if it's not a military objective, I think if you look at the intent behind this law, I think that would have to bring that additional protection into play. But if you're talking about it as a military objective, right, then I think you're going to lean more towards your proportionality analysis and determining the effect on the civilian populace.
So no special protection unless you're an AP1 state for installations containing dangerous forces?
I'll have to check that. Off the top of my head, I did not in the paper address whether that was a customary protection, and it's not immediately popping to my mind whether that is and exactly what that customary protection would be. So I'd have to go back and check on that.
And just a very quick follow-up. There's also, at least in the additional protocol, an obligation to take constant care to avoid harm to the civilian population. That's over and above proportionality and over and above the classic precautions in its act. Does that constant care analysis factor into this at all? And it would be a scenario in which the consequence of the ransomware attack does not generate harm that would normally be considered in a proportionality analysis, like physical damage or injury, but nevertheless disrupts civilian activities and thus would be subject to constant care.
Yeah.
Have you thought about that?
Yeah, it's a very good question. Right. And my understanding is that the US does not believe that the constant care provision constitutes customary international law. But for those states that are a party, I still think what that means, what constant care means is pretty nebulous. And so I did not address that as part of the paper. Perhaps that's something that I should have addressed as part of the paper. But I just think that there's so many other specific provisions that get towards that, as opposed to looking at something that's so vague as constant care, which is, I guess, why I really didn't include that as part of the paper. I think that would have required, and I wouldn't say it was an intentional exclusion, but as I think about it, I think you would have to dig into so deeply into what different states believe that constant care requirement means, that I think you would probably usually fall back on the more individual specific things that are addressed here. Do you disagree?
No, I think you're right, but I think it's a really interesting question in the context of ransomware.
Yeah, and it kind of gets into similarly, right? You've got the article, the basic rule on distinction under Article 48, where it's talking about shall direct their military operations only against military objectives, right? And so a lot of people argue, well, military operations is much more broad than attacks, right? And I think that's where I believe you and I agree on the point that, well, because there are so many more specific provisions, you kind of have to see that provision as a chapeau that's just basically introducing the idea, and then the rules get much more specific throughout that chapter that provision leads off with. And so I think you would have a similar kind of a thing here with constant care. It's like, yes, right, we understand the overall objective of international humanitarian law, and that's providing us with a restatement of that overall objection or overall objective. But then we have to get down into the more specific rules where it really starts to talk about the actual limitations as opposed to a general ephemeral notion of what it means to be humanitarian.
Thanks, Jeff. And by the way, great article, and we look forward to your article of war post on this.
Yes, it will be done very soon, very soon, in the next couple of days. Like many civilians, I might not be working next week, so I'll have lots of time.
Well, we've gone a bit over time. I want to thank everybody who has stuck with us. I'm happy to keep it open for another minute or two. If there are any final questions that anyone was keeping to the end, Jeff, if you're available.
Oh, yeah, I'll stay on. I'm free.
So otherwise, thanks for joining us, and hope you'll join us next time. And thanks a lot, Jeff. Are there any final questions?
Jeff, I have one final question that you may want to think about if you have a minute.
Yes, absolutely.
So I've thought a little bit about ransomware, and here's the scenario. Lots of states are giving assistance to Ukraine, military assistance to Ukraine. So the Russians decide to conduct ransomware operations against the private entities that are producing that weaponry. Stop producing weaponry that is passed on to Ukraine, or we'll keep your company shut down. And I'm not sure I know the right answer to this question, but is that then governed by the peacetime rules governing cyber operations? Is this an issue of neutrality, instead an issue of neutrality, which brings in all these very difficult questions of neutrality and the provision of military assistance to Ukraine? I don't know if you've thought about it at all, but it just strikes me as really an interesting scenario.
No, absolutely. Have thought about it. I mean, so neutrality is one of those, like, if you're a neutrality scholar, and there are many fantastic ones out there, like, you are loving this conflict, right? Because it's taken an issue that was, I won't say completely dormant, but didn't receive a lot of discussion prior to this conflict, and suddenly it's at the forefront. And it spurred a lot of evolutionary thinking on what it means, what those laws or rules mean to be neutral. Right, and particularly as you see a progressive and an increased direct support, right? Not just, it's not just Raytheon or Lockheed providing selling military equipment to a party. It's the actual states directly providing military equipment and other resources to one party of the conflict, and the status of their neutrality as a result, I think, is very much up in the air. I think it's become more of a political question necessarily than a legal question, both from the Russian standpoint and from the states providing the provision of those materials. They're almost a risk analysis question, right? How far can we push this before, before Russia decides to overcome whatever stumbling blocks it may have to declaring that these other states are a party to the conflict or in violation of neutrality. I'm pretty sure they've already said they're in violation of neutrality. And they've said things like the activities of these states are akin to an act of war, whatever that means. So I think your question, I think right now you would kind of have to conduct simultaneous analyses of whether that would be a something to analyze under peacetime rules, or whether you would analyze it under IHL rules, depending upon your view of the neutrality question. I would not consider myself a neutrality scholar, and many people have written much more interesting articles. You can go to, you mentioned Articles of War already. There are some very good neutrality articles. We addressed the issue, a couple colleagues at the Academy early on related to space, right? Particularly Starlink and the provision of Starlink services to the Ukrainians. under similar types of questions. I know Professor von Heinig has written several very interesting articles related to the conflict and how we should view neutrality with an aggressor state like Russia. So, you know, I would be tempted at this point to prefer to look at it under the peacetime rules, because I don't think we can definitively yet state that the United States is a party to the conflict. Or that we're in violation of the laws of neutrality. But I think it would be hard to argue that if Russia were undertaking ransomware operation to prevent the supply of war materials from the United States to Ukraine, it would also be hard to argue, given that precedent that's being set, that they're somehow in violation of international law. I don't know if you have thoughts on that.
Well, I mean, I think you hit the nail on the head. I think it really depends on whether or not you consider the provision of assistance to be a violation of the law of neutrality. By the strict neutrality view, it is clearly a violation. States may not provide aid to a belligerent. Neutral states may not provide aid to a belligerent, which would open the door to the aggrieved belligerent, in this case, Russia, taking measures that are necessary to put an end to a breach of that body of law. In other words, a self-help a remedy. And there are some great folks. Pete Pedroso out here at the War College certainly takes that view on strict neutrality. Now, von Heinig and I, a few others, have taken the view that this is and the Department of Defense Law of War Manual, that qualified neutrality is in play here, meaning that we are not in violation of our neutral obligations, meaning that in the event that the Russians begin to conduct such operations, my guess is that it would either be considered under peacetime rules, or it would be considered as a military operation into neutral territory, and therefore a breach on that basis. But I don't know the answer. I think for the folks listening, this will be a fascinating thing to dig into.
Yeah, I mean, and even if you looked at it purely from a peacetime analysis, you're still going to struggle with a lot of the similar issues to what we're right. There are obviously different laws, intervention laws, sovereignty laws that are going to come into play. But the answers in that situation are by no means simple either.
But anyways, thanks again, Jeff. I really appreciate the presentation.
Great questions. Thank you so much for attending. I think you added a lot with your questions. I very much appreciate it.
All right.
Okay, with that, I guess we'll wrap it up. So thanks again for everybody for attending, and Professor Biller, thank you very much for presenting your paper for us.
Yeah, go out and download it and then cite to it. My shameless plug.
All right. Thanks, everyone.